Two people contemplating marriage may enter into a prenuptial agreement before they are legally married. Two people may also enter into a postnuptial agreement, but this would only occur after they are legally married. If both are contracts governed by state law, and two people sign these contracts voluntarily, how are they different? Well, how each is treated will ultimately be determined by state law. But perhaps one of the biggest differences between pre- and postnuptial agreements are the conditions required for each to become actual contracts that are legally binding on the parties and enforceable by a court. Each state will have its own body of law making such determinations. But what is important for you to know is that the requirements to become valid contracts will likely be very different in your state for a pre- versus a postnuptial agreement. So if your prenuptial agreement expired after, say, 10 years, and you and your spouse simply executed an exact copy of your prenuptial agreement, extending it another 20 years in your kitchen, would it be a valid contract? Well, depending on your jurisdiction, very likely it would not. Given the potential for unintended consequences from entering into pre- and postnuptial agreements, it is essential for two people considering them to each retain their own lawyer to represent their own interests when negotiating and drafting such agreements. I'm estate planning and tax attorney David Gerszewski. Thank you for watching our video blog.